Before we begin this program, I want to thank our Howland Science Center members for their support, which makes our event programming possible, as well as the Gerald R. Ford Presidential Library and Museum and Grand Valley's Poli-Sci Department for partnering on this event. As this is a Common Ground Initiative event, it seems important to me to mention what may seem obvious. You may hear things tonight that you disagree with. In fact, I hope that is the case. Whatever disagreements we may have, I urge us to keep in mind that our collective presence here today is evidence that there is common ground to be found if only we can find it. I ask that we all practice humility and engage with ideas different from our own with curiosity and with respect. As many of you know, a key component of the Howland Science Center's programming is the Peter C. Cook Leadership Academy. Every year, a cohort of student leaders join us for a unique leadership development experience. At each event, we invite one of the fellow candidates to present a leadership minute, a brief reflection on their personal leadership journey. It is my privilege to introduce you CLA fellow candidate Mallory Everly to share her leadership minute and to introduce our moderator for the evening. Mallory Everly is in her third and final year of studies at Grand Valley. She is majoring in multimedia journalism with a minor in political science, and she is hoping to attend law school after her time at GVSU is completed. As a first-year fellow candidate, Mallory is very excited to collaborate with leaders from various fields in an effort to better one another and develop a strong network of support. Outside of coursework and school organizations, Mallory enjoys exercising, reading, writing, and spending time with her friends and family. Please join me in welcoming Mallory.
Good evening, everyone. My name is Mallory Everly, and I am a Peter C. Cook Leadership Academy Fellow candidate. My passion for civic leadership and engagement began when I was 14 years old during my first week of high school. It was during this week that I started taking my first ever AP History course, and as you may guess, I loved it. Fast forward to the first week of my sophomore year of high school, I enrolled in my first ever AP English class, and I loved that one even more. Taking each of these courses relatively close to one another allowed me to discover my love for constructing arguments based on facts, while also utilizing various rhetorical structures that required a vivid sense of creativity. So naturally, I decided to pursue a career in law. However, you may be surprised to know that my field of study here at Grand Valley is not actually legal studies, it's multimedia journalism. When you think of journalism, you might think of reporting, news articles, interviews, but the field of journalism is truly all about how to communicate with other people. And a problem that we commonly run into is that we view communication as a two-way street rather than a singular tool that unites all of us. Similarly, when you think of the Constitution of the United States, there are traditionally two ways of viewing this document. There are originalists who believe that the document should be interpreted in the same way that it was when it was written, and there are modernists who believe that the document evolves as the world changes. Much like the field of journalism or an argument in an AP English course, this two-way street of legal interpretation has become a method of isolation rather than a tool of collaboration. Regardless of how differently you may view the Constitution from the person sitting next to you, it applies to every single one of us each and every day. Take the First Amendment right to freedom of speech. Regardless of how different we are, we all use that every single day, and that makes us similar. The Constitution shouldn't be a divisive topic. It's the constant thing that unites us as we the people. It gives us the ability to disagree when we want to. You can ask my older brother for clarification on that. But it was also meant to prompt civil discourse and engagement. It was meant to bring people with different opinions together for a common purpose. It was meant for us to sit down, get to know each other, learn about what makes us unique, and learn about what it is about those unique traits that can contribute to positive impacts for all of us. When I applied to the Cook Leadership Academy, I was hoping to interact with other students who were interested in legal careers. I thought that this was my best shot at preparing myself to be a future law student, successful attorney, and a civically engaged citizen. And although I have learned so much from my fellow legal peers and professionals within the field, I have learned equally as much, if not more, from pre-veterinary majors, social work majors, business and nonprofit administration majors, and many, many others. I have learned the most from simply communicating with people who are different than I am. Different ideologically, different values, different passions, different life experiences, and yes, different views of the Constitution. I have learned that the greatest opportunities for growth, collaboration, innovation, effective change, and something that we all crave, relatability, are in environments with the most versatility. My name is Mallory Everly, and I am a leader. It is now my pleasure to introduce our moderator for tonight's event. Jeffrey Rosen is the president and CEO of the National Constitution Center, where he hosts We the People, a weekly podcast of constitutional debate. He is also a professor of law at the George Washington University Law School and a contributing editor of The Atlantic. Everyone, please join me in welcoming Jeffrey Rosen.
You so powerfully encapsulate the essence of a constitutional discussion. You're so right that the debate between originalists and modernists polarizes the discussion, and the point of the Constitution is to provide us for a framework for discussion. I love what you said at the end about how it's conversations that have the most diversity and engagement and versatility was the word you used, that are really most constitutional in spirit. So thank you for that, your leadership. Bravo. We're here to discuss another inspiring example of constitutional leadership, and that's the National Constitution Center's Constitution Drafting Project. A few years ago, I guess, it was almost 2 years ago now, we convened 3 teams, conservative, libertarian, and progressive, to draft a constitution from scratch. The conservative and progressive teams were led by Ilan Wurman and Caroline Fredrickson, and I'm so honored to welcome them and introduce them to you, and to say that what they achieved together is among the most inspiring projects I've ever been involved with at the NCC. Because in the space of about a week, in a state of nature or a state of Zoom, I guess it was, these 3 teams of scholars who disagreed strongly about politics were able to agree on 5 proposed amendments to the Constitution. And those amendments were discussed today by the great students, and we'll discuss them tonight. But it's such an inspiring example of how in a civil framework where the participants are deeply informed, you all had a deep knowledge of law, and a commitment to finding common ground and compromise when possible, and to disagree productively, you actually can converge on some very basic principles. I want to achieve a bunch of things in this discussion. We're going to talk about the Constitution Drafting Project. We're going to talk about the amendments that the students proposed and what you thought of this evening's deliberations. And maybe I'll start by asking, what is it, to pick up on Mallory's point, what is it about your convention or a convention in general that is conducive to this kind of constitutional level discussion? The framers are creating a distinction between ordinary politics in Congress or state legislatures, which can pass laws that aren't supposed to stand for the deep will of we the people, and a constitutional discussion where, because the delegates are specially chosen, they're really informed, they're committed to deep conversation about principle rather than politics. What emerges from those conventions, it represents the will of the people more profoundly than ordinary laws. You were able to agree on these amendments because you're such a well, I'll ask you why. You're such a well-informed, deeply educated group. You were committed to finding some kind of common ground. Broadly, what's a constitutional convention supposed to look like, and why was yours so successful? Caroline.
Well, thanks, Jeff, for that question, and thank all of you for being here tonight. It's a great opportunity to talk about a project that I really loved working on. And I'd actually say, Jeff, when you first said 2 years ago, I thought, wow, Jeff, I know time really flies, but this was really 4 years ago that we started the whole project.
Wow, you're right.
Because I sort of think about it as what you read about moral philosophy during the pandemic, and I read a lot of con law and talked to a lot of con law scholars. When you asked me to lead the progressive team, I was coming off a job running the American Constitution Society, where I was obviously spending a lot of time thinking about the Constitution, but I was going to Georgetown Law School, where I was going to actually be teaching constitutional law. So it was a wonderful opportunity for me to actually really go back to law school. And I spent a lot of time talking to constitutional law scholars about what they would do. You know, what were the things they thought were most important? So my sort of lead into this was starting with trying to see what consensus there was at all among sort of the kind of moderate to progressive side of the sort of legal academy. And then what I think made this project really work was that you and a few others had really noticed that when we did produce these constitutions, that there were already areas of overlap. That we had agreed on some particular areas that where the Constitution could be improved. And there was a lot that was different in the three constitutions too. But I think that was really, that was a really insightful moment, because I'm not sure we would have expected that from the beginning. And so that, I think, led everybody to have a kind of openness to the idea that we could actually hammer out actual language, because we'd already indicated there was a possibility for agreement here. And then, it was 3 days of, some very good and hard discussions. But we talked about this earlier, but it was sort of the importance of compromise in this kind of a discussion, right? It's not an all or nothing. If you really believe that we'd be better off with some version of a fix for this particular provision of the Constitution, it's not perfect from your point of view, but it's better than what there is, you give. Say, okay, well, you come a little bit my way and I'll go a little bit your way, and we'll end up with something that we can agree with together. And I think that was what people brought to that they were open to the idea of giving something up.
Beautiful. It's so important to tell the history, as you just did. And as you say, it was 4 years ago that we convened you as teams to draft constitutions from scratch. You produced your constitutions without talking to the other teams, and we were so struck by the fact that, far from throwing out the Constitution, each of you built on it and proposed to amend it in ways that were, in some cases, similar. And we, having identified those areas of overlaps, convened the three of you. And then let's give some props to Ilan, who did such great organizational work and was really a leader in coming to compromise. So Ilan, tell us why you think this project works so well, and what are the characteristics of a successful convention?
Sure. So I think starting with the successful conservative convention, because of course we had our own convention, if you will, 3, in our case, sometimes 4 people that were a bit hard to organize, which is why we actually had an additional team member. But it averaged out to 3 members on any given day. And the answer to us was structure more than anything else. When you're drafting a constitution, when you're trying to agree on not immediate policy issues and policy questions, but you're trying to structure a government for the future, sometimes you have to put aside hot button present day political controversies. You have to look past the present moment. So on our team, there was a debate. Do we enshrine a right to life in the Constitution? Do we abolish the Supreme Court's decision for same-sex marriage? And it turned out actually that we had different opinions about these issues. But what we actually coalesced on wasn't that, we're not going to come to agreement because we disagree on these, but hey, maybe these don't actually belong in a constitution. Now, that's not to say that certain rights don't belong in a constitution. Certain rights are absolutely essential to free societies, okay? But when you think about what our constitution actually protects in terms of these rights, it's a pretty minimum essential, like those most fundamental rights: freedom of speech, religion, right? Freedom of press, assembly, petition, these preconditions for a free society, if you will. People disagree. Self-preservation rights in the Second Amendment, whether that's essential to a free society, and then lots of due process rights. right? Before the government can kill you or throw you in jail, there are all these protections it has to follow. But for the most part, the Constitution doesn't otherwise enshrine a particular political view or in terms of what rights people should enjoy. It's mostly about structure. And so what made internally our team very successful is that we focused on those kinds of issues. So debt burden, which was an example, there was a balanced budget amendment today. Ours, we weren't focused on balanced budget in Team Conservative. We focused on the national debt shall never exceed a certain proportion of GDP except in times of war or emergency, and we provided for that. That's a structural question, right, about allowing future generations to govern themselves. It was about channeling democracy in a certain way. We debated a proposal to have the Senate deliberate in secret. But then we decided that would be too anti-democratic, even though we thought it would enhance the deliberative process, right? So that's what we thought about. And then when we come to this convention of all three teams together, it won't surprise you to know that the 5 amendments were all structural amendments. Because we weren't going to agree on things like, abortion and marriage and whatever other rights that progressives and conservatives and libertarians disagree about today. But it turns out that there were structural things that we could agree on, like giving Congress more of a say in the legislative process, which, we agreed on a legislative veto provision, which wasn't as popular this afternoon as I thought it would be. But I take the blame, perhaps, for my impoverished explanation of the obviously amazing amendment that I'll propose. But, so all of those things work together. And then I would just echo what Caroline said, which is, it turns out not only can there be common ground, okay, but sometimes you just have to give. It's like, I don't like X, Y, or Z, but I'm willing to give that to you because I care more about A, B, and C. And so let's put it together. And so it's not just common ground, it's about compromise. And then, of course, it turns out you can like someone even though you disagree with them about basically everything else. And I think that's important.
So important. And you said so many important things, including that the Constitution is made for people of differing points of view, which Justice Holmes said as well. And it's an important insight that you were better able to agree on structure than on rights. This afternoon, there was that great question from the gentleman who said, what do you do about government interference or guidance about morality? And you're suggesting that citizens and representatives disagree fiercely about moral questions, but they might be able to agree on structural questions. And that was the initial great insight of the Constitution. Well, let's perhaps talk about how your amendments fared today to the degree that you followed and participated in the discussions. It sounds like the natural-born citizenship amendment that would eliminate that requirement for president may have done pretty well. Caroline, tell us about what you observed today about that amendment and others.
Well, I mean, the whole process was really very impressive. I think people really grappled with the text they were looking at and also what was behind it and the implications. So consequences matter, right? So it's not just something in the abstract, but how it will actually affect people once it's been adopted. And I was really impressed with this serious endeavor that people undertook to try and come up with positions that they could support, and then also some really incredible questions about the text that came out of our project, which I think were very helpful in terms of how we might tweak them or going forward. And so that being said, I think I was given the easy lift. I'd like to take credit for the fact that was the amendment that got the most support because of my wonderful presentation. I think it was really that it was the low-hanging fruit. It's such an antiquated concept from the world that we live in, especially people are much more mobile than they were, and we are all familiar with a lot of people who have came to this country and founded incredible companies and universities and made scientific contributions or cultural contributions and have led to the richness of American life. And so the idea that you actually have to be born here to be president, I think, would exclude so many important contributors. So that was, I think, just the sort of the aspect of that amendment that was one of the reasons why in our constitutional convention in Philadelphia. Well, actually, it was virtual. We had an event later on in Philadelphia, but why it was one of the amendments that we knew that we could agree to, because it just doesn't really make sense anymore.
Fascinating. Ilan, why do you think your amendment, the legislative veto amendment, did less well? Describe the debate. Did students make speeches for and against it, or just ask you questions? And what does that say about the fate of structural amendments? Do you have to be a constitutional lawyer with a deep background in order to understand the importance of something like that?
You just have to be convinced to listen to the lawyers. No, at least listen to the constitutional law professors. But no, I mean, in a sense, these are kind of related issues. I had to explain each sentence of that. What is a legislative veto? And then, okay, what's the history of it? Why are we trying to include it here in the amendment? And then there was another exclusion. The veto won't apply to these certain situations. And it's like, well, why is that excluded? And then we had a final sentence about whether this will, a failure to exercise a legislative veto will affect judicial interpretations of regulations enacted, pursuant to laws of, like, whoa. Each one of these things was included for a very specific technical legal reason in order to, get at the objective we wanted without doing collateral damage to other issues and gather support among the lawyers. And each of them, as you can already see, your eyes are glossing over, it's required, explanation. Let's put it this way. We're not in the midst of the Vietnam War deciding whether 18-year-olds should get to vote, okay? People are not going to crawl over broken glass to vote for our legislative veto amendment. To be clear, I will crawl over broken glass, but I'm not sure anybody will follow me. So, I trust our medical system to take care of that comes to it. And so it is difficult. It's, look at all of our amendments. 5 of them had to do with the right to vote, expanding the franchise. Most of them have to do with fundamental rights of some kind. Since the founders, how many of them dealt with structure? Actually, now that I'm asking the question, any? I mean, limiting the president to 2 terms, I suppose, is
congressional pay.
Somewhat structural. Well, some of us don't think the 27th Amendment was validly ratified, but that's a different. That's a different inside baseball discussion. But yeah, that's part of the problem.
Well, and for our friends who weren't at the convention, the legislative veto used to be exercised by Congress to repudiate executive actions it didn't like by majority vote. And the Supreme Court, in a case called Chadha in the 80s, said you can't do that, it violates the separation of powers. So this convention's amendment would have resurrected Congress's power to say to President Trump or President Biden, you can't build the wall or end student debt, and Congress can do that by majority vote without a filibuster. And that's why it was a bipartisan thing, because both sides thought, hey, Congress should be able to assert its prerogative. Why should they need 2/3 votes in order to say what they mean? But as Ilan described, the level of technical detail was high. I have to say, I listened to their deliberations on Zoom, and I felt like I was listening to modern day framers. That was how high the level of debate was. They were having technical discussions about words, which I couldn't have participated in because I'm not as up on the legislative veto stuff. And they were discussing what should happen to the president who's been impeached. Should he be able to run for a state office, and citing history? So this is kind of, James Madison and his modern day successors right here. So Caroline, what does that say about the practical feasibility of another convention today?
Well, I think that the process of convening a convention is perhaps more akin to what happened here today, which is broader points of view and questions from people who are not necessarily as steeped in the case law and the constitutional history. And that's really important, I think, in order to make sure that the amendments are drafted in a way that really speaks to people. I would just say there was a very interesting comment on the natural-born citizen requirement, where there were some comments asking why we hadn't included an age limit. And I thought that was really interesting. They're certainly contemporaneous. When somebody asked about what about somebody who's been convicted of a felony, so bringing in kind of maybe perhaps more modern concerns about who might run for president or be eligible to be president beyond what we were thinking about, which was simply revising this one provision in the Constitution. So I think, with the legislative veto, I think that is just, I think the text, and one of the reasons why it was so complicated was it was really the product of a great deal of compromise. There was an general agreement that Congress has gotten too weak relative to the other branches. And one of the ways that perhaps that could be addressed is by enabling a legislative veto, not exactly the way it was exercised in Chadha, but a two-house legislative veto, as you mentioned, obviously not allowing a filibuster. And of course, the president can't veto a veto. So taking the president's role out of otherwise a congressional legislative act. But because of some concerns, I think they were mostly from the libertarians and conservatives about other doctrines in constitutional law, the non-delegation doctrine and so forth, that added those kinds of additional provisos. And I think that ends up, if there was a kind of broad engagement of a larger group of people in an ongoing convention, I think there would be a lot more explanation that might make it not seem so technical and complicated. Mm-hmm. So I do think that is sort of a window into how a convention might be structured now. We'd obviously have social media, right? Everybody would be tweeting or whatever it is, Xing. What do you call it? Threading. Out of the room, and there'd be commentary, and I don't think we could have a blackout like they did in Philadelphia and try and keep the journalists out of the room and keep people from communicating. But so public education is a really important piece of all of this, and I think as really came up in your wonderful book talk, we don't read enough as a society anymore, and hopefully if there were a constitutional convention, there would be people, sort of inspired to read more, to think about these issues in a deeper level. I mean, I'm not holding my breath, but that would, I think, be a requirement.
It's so striking how high the level of debate was in the convention, in Congress for so much of American history, and that, and the question, Ilan, is that possible when people are Xing or tweeting or whatever they're doing and commenting in real time? And there's no secrecy, and there's a need to do everything on Instagram and to have sound bites, and in the course of the answer, maybe why don't you try to make the case to our friends here for a legislative veto amendment as kind of crisply and untechnically as you can, and then we'll see whether they're convinced.
So the short answer is no. It's not possible in that world. Partly it's why we flirted with the idea of having the Senate deliberate in secret, for example, right? At least get rid of the C-SPAN cameras, right? At least force them to actually be present. There is a provision in the Pennsylvania Constitution that requires members to be physically present on the floor when there is a vote. They have to be there. They have to listen to each other. Like, we actually proposed one of those in the conservative Constitution. And so it's just impossible when everything is performative, right? And nothing is deliberative. So our convention, was it recorded? But we decided not to release the recording.
It is recorded, and you can choose to release it if you like.
Right, but over my no.
Absolutely.
So, because look, when you're in these things, you're willing to say certain things. You're willing to give up certain things that the true believers on your side are going to try to excoriate you for. And you just can't get anything done. And Caroline and I were having this discussion about how Congress also, used to, there used to be give and take, but now you can't. The second you try to give,
That's not C-SPAN.
That's not C-SPAN. That's other factors.
That's, yeah.
C-SPAN contributes. Like, I don't know. Maybe I'm just also less of a fan of a free press, than Caroline.
Well, obviously.
See something that I'll deny ever having said.
Or democracy. I mean, I think deliberation in public by elected officials is really important. I would say when I worked on the Hill for a long time, there were lots of conversations that happened off the floor of the Senate or the floor of the House. There are lots of negotiations. Senators meet with each other, and they used to do this more, right? They'd have dinner together. There was social life. And there were a lot of conversations. So the dynamic is really much more about that than the fact that there's a camera now on the Senate floor. when they're talking. The dynamic is that that the hyper-partisanship that has broken down the life outside of, when they're on the floor, they're going to disagree about policy matters. When they were off the floor, they used to be able to negotiate the stuff, or at least to some degree, right? Everything couldn't be negotiated, but I'm sorry, I jumped in on this. I just think it's, an important point about sort of the modern world that we're in.
Just before you make your case, I'll put the question historically. Were Hamilton and Madison right that you really needed elite representatives to engage in this deliberation, and that pure democracy would lead to the mob?
Okay. So you're gonna just throw that out there before I answer the previous
We can save that for the closer, but first we have to figure out whether democracy is plausible.
Look, we believe in Madisonian deliberation. That was the driving spirit of the conservative constitutional effort. Okay, the libertarians, Caroline joked earlier today, maybe it was at lunch. They not joked. It's true. They joked. Not even joking. They meant this seriously. They barely touched the Constitution. And they said, we think our Constitution is libertarian, which, of course, you should always be wary of people who think the Constitution always leads to their political ideological outcomes, right, in every single case. And they wanted to just say, and we really mean it, right, after every clause of the Constitution. Okay, so they focused on, I guess, liberty. I take Team Progressive to focus a lot on equality, though this is a simplification. And Team Conservative focused on this idea of Madisonian deliberation, this idea that, yes, of course, the framing generation understood that mankind must have a capacity for self-government, for this experiment in self-government to work. But they also understood that mankind had a profound capacity for depravity. They say that also in the Federalist Papers, right? If men were angels, no government would be necessary. We talked a bit about this at lunch. The separation of checks and balances that they created was so that ambition would counteract ambition, right? Not, if the free market of ideas will prevail and truth will prevail, the people will do what's right. No, nonsense. That's ridiculous. Okay, I certainly think that they believed that it took an elite group of people to set the Constitution in motion. But I firmly believe that the Constitution they created was intended to endure as a document that could accommodate people's passions and avarice, and assumed that people would not always be these Stoic philosophers or philosopher kings and so on. And so it's a balance. Obviously, we believe in self-government, but as Madison said, the whole act of writing the Constitution was finding Republican remedies for the diseases most incident to Republican governments. Okay, or as you mentioned at lunch, right? What is it that Hamilton said? If every Athenian had been a Socrates, every Athenian assembly would still have been a mob, right? So it's of course, it's self-government is better, the best form of government we've discovered, right? To help secure happiness and secure liberty and so on. But that's not enough. It has to be checked, it has to be balanced, it has to be channeled, but ultimately remain Republican in principle. Now, is that a decent distillation of 100 years of political philosophy and thought? I did my best.
It's a very powerful distillation of the Federalist view of Hamilton and Madison when he was writing the convention. Representative democracy would filter passions, and thoughtful elites would guarantee the rule of reason. And taken to its most extreme form of Hamilton, it's a deep distrust of direct democracy, but a faith in republicanism defined as no hereditary offices and having some accountability to the people through indirect representation. So Caroline, is this a difference between Team Conservative and Team Progressive? Do you have complete faith in direct democracy and the people, or do you share some Madisonian concerns?
Well, I'd say we didn't disassemble the Congress as it exists. So we maintain representative democracy, not direct democracy. We did add some elements. For example, getting rid of the Electoral College was one important piece for us to enable the popular vote to choose the president, to avoid some of the problems, one could call them, or unfortunate outcomes, depending on where you sit on the political aisle, but certainly an anomaly from the point of view of every other country in the world that actually has a real democracy, that the popular vote doesn't, if you have in a presidential system, doesn't elect the president. And so, but we did, want to enable certain other forms of direct democracy, such as ensuring independent state redistricting commissions. That is because of the fact that state legislatures and Congress as well are so heavily gerrymandered, it means that it's almost impossible to undo that. They never want to, so if you leave it in the hands of the legislators, well, they're the ones who created it, so they're not exactly going to undo it. So we wanted to hand over that particular aspect. So I would say there was actually a lot more overlap in that sense. Where we did address issues of democracy, I think, is to get back to sort of when you were suggesting that, do we have to have elites guide this conversation? I think it has perhaps some degree, well, there are two aspects to this. One is who is an elite and who do we consider capable of representing us? And I think that, view has obviously changed a huge amount since the founding. And, not to pick on you, but you said mankind. I would say humankind. I think it's, the way that we have understood who we the people is over the course of American history is certainly changed in very important, significant ways. Our society has changed to the better very significantly because of our recognition that we the people is all of us and only not just a few of us. But the other thing that we did address in our Constitution was the right to vote, where there was one amendment today that considered removing certain disabilities on the right to vote. That is, if you've been somebody who had been convicted of a nonviolent felony, you would be able to participate. That would not be a barrier to voting. Similarly, people who live in the U.S. territories. But what I thought was, well, it's interesting that there's not just suggesting an affirmative right to vote, because that's in the negative. That is, you can't be discriminated against because you've had a felony conviction, or you can't be discriminated against because you're in a territory. Whereas our Constitution actually established an affirmative right to vote in the Constitution, which we don't have. We only have those kinds of negative. You can't be discriminated on the basis of race. You can't be discriminated against because you're a woman. But there are lots of other ways that the right to vote is not protected.
It is striking that there's no right to vote in the Constitution. And Ilan is Team Conservative against expanding the right to vote to previously excluded groups. At the founding, this divided the Federalists and the Jeffersonians. The Federalists want to maintain property requirements because they think the people are too uneducated to vote wisely. And the Jeffersonians want to basically eliminate property requirements for white men. And then the Democratic Party in the 19th century extends the right to vote to, and the Reconstruction Amendments extend it to African Americans, to women, to previously excluded groups. Are conservatives against this, or are you okay expanding the franchise but coming up with other filters on direct democracy that would ensure the rules of reason?
Yeah, let me just be clear that conservatives, even if they were against it, accept that the Constitution has been amended to expand the franchise. But let me just say, yeah, of course we support it. Yeah, right? I mean, I have a book called The Second Founding, which I think you could buy after this talk, where I talk about how the Reconstruction Amendments, and particularly the 14th Amendment, perfected, if you will. Obviously, there's still work to do, but made it a more perfect union, was improved dramatically upon the original Constitution. And of course, bringing half the population that had previously been excluded from participation in the regime back into the regime makes us a stronger society.
Well, not yet women.
So, well, this was right 1920, fast forwarding to the progressive era. And I even support, if you can send someone off to Vietnam against their will to vote, to die for the country, then I suppose they should have a say in whether the war goes on. Now, the proposal today was, to extend the franchise to those who are convicted maybe of felons, nonviolent felonies, and then to lower the age to 16. Which
and territories.
And the territories. Yeah. Which is all a way of saying, by the way, that when you actually propose these amendments, like in the real world, why don't you pick one? Because you never know who's going to, the more you try to do, the more people are going to disagree, probably. And then it's just going to be defeated.
Which is why I had suggested to her afterwards, I said, just go for the right to vote.
But like, look, if one nice thing about federalism is we can see how things work in a way, right? So California there was a proposal, was it California? No, someone proposed lowering the voting age to 16.
That happens in Tacoma Park, Maryland, though, right?
It does. Oh, yeah. But by the way, to
non-citizens
go back to the Electoral College point, you cannot do this without the Electoral College. This is a very important point. Because if California could just increase its voting base by adding 16-year-olds, adding non-citizens, well, surely it can't be the case that now they get more say to vote for president, right? This is actually why the Electoral College, part of the reason it was originally created, because the franchise wasn't the same in every state, right? And so how you do it, you assign a certain number of votes per state, and then those states can decide who in that state votes, right? You can't do that without the Electoral College. Okay, so that's just kind of an interesting point that if you want that experimentation, it's very difficult to do it.
Although it happened constantly in American history, because I was privy to a wonderful paper that one of my students wrote in my seminar last semester, talking about the vote of immigrants, non-citizen voting, and how common it was in the United States until actually much more recently than we would expect. It was until it started to be outlawed at certain points, often dealing with the migration of groups that those currently in power were less comfortable allowing to participate, and wasn't actually overtly made illegal until, I'm trying to remember the date, in the 20th century.
Wow.
Since we are talking about expanding the franchise, can I throw something out there that was just posted on SSRN, the Social Science Research Network, by a Harvard law professor and a Northwestern law professor? Very provocative. I'm not saying I endorse the idea, but if you want thought-provoking ideas, the paper is called "Give the Parents the Vote," and it says that their voting power should be proportional to the number of children that they have, and they account for all sorts of things. Until they reach majority, right? So children under age of majority, and they have all sorts of solutions. No. Actually, Josh Kleinfeld, but I can see why you and Stephen Sachs at Harvard Law School. So they propose this as a way to represent the interests of children who are not represented in the political process. Actually, even though many things happen that affect their interests. So it's very, very thought-provoking, and it seems wrong, like as an intuition, but when you read it, it's like, is it wrong? It's one of those things where you feel like maybe it's got to be wrong, but you actually can't put your finger on it. It's really interesting. And so I don't know what you think about it. I just wanted to throw it out since we're having the discussion.
Let's put on the table the handful of amendments that you proposed we haven't discussed yet, and they included term limits for Supreme Court justices, about which there was broad agreement, as well as making impeachment a little harder in the House, but easier to convict in the Senate, and making amendment a little easier. These are tell us about those amendments, Caroline.
Well, those were amendments that were really easy in concept and hard in language. That is, it took us a long time to hammer out exactly how we would frame these in a way that we could all live with. So term limits for Supreme Court justices is something that has very broad support across the political spectrum. And it was an issue that was in the progressive constitution, was in the conservative constitution, but not in the libertarian constitution. But they were okay with the idea. And thus, we sort of started from that place. What kind of started getting tricky was, the issue of should we explicitly state the size of the court? It's not in there now, right? It seems a lot of people are surprised by that. 9 is just the sort of has been the most common number, but not the only number in American history for the size of the court. For the conservatives, that was important, that it be fixed at 9. And in order to make the whole project work, we, sort of focused a lot on sort of mechanisms. And these weren't necessarily ideological differences. They were actual practical implementation questions about what happens with the filibuster in the Senate? What if, in order to make this work, you have to have, every president gets 2 appointments. You have to figure out how those 2 actually happen in the real world. where there's a filibuster. Now, it's been removed by Senate rules for Supreme Court and lower court nominations, but it could easily be reinstituted by the Senate through its own rules. So how do you deal with that in this process? So you basically, I mean, we're amending the Constitution so we can do what we want, right? So for these purposes, you make it so that they're, you fix the size of the court at 9. You give every president two appointments. The Senate basically has to vote within a certain period of time. We didn't want to force them to have to vote to support a president's nominee, but there's a kind of they have to vote within a certain period of time, up or down, or it would be deemed approved. So that took just a while to kind of work out the implementation side. It wasn't so much, again, as an ideological difference, because we all agreed that it is, again, completely anomalous to have the highest court of constitutional review with lifetime appointments. It definitely has, is problematic in many regards, and we all agreed with that. As for the impeachment, we also all agreed that we have a system in which it's too easy to bring impeachment in the House, and it never goes anywhere in the Senate, right? It's a fun political, I don't know if it's fun, but it's a political exercise. There's a lot of showboating that can happen in the House, and then the Senate basically is never going to do it. They've never done it, right? They've never done it, and they probably never will do it. In terms of a president, they have done just a few judges, lower court judges, and that's sort of the history of impeachment. So it doesn't work as a mechanism as it's supposed to be in the sort of the sense of checks and balances. One of the few tools to check a rogue executive. So by raising the standard in the House, the burden. We wanted to make it harder for the political exercise to actually, the showboating to actually be so useful to hyper partisans. On the same token, if it becomes something that has this kind of supermajority support in the House, the Senate shouldn't have such a high burden of convicting because. One of the things that's so well recognized now is that, that when the framers conceived of the sort of separation of powers and the three branches, that checks and balances was in part supposed to be based on the interests of the institutions. That is, Congress would want to protect its sort of institutional prerogatives, the executive as well. And so that if there was an agreement that a president needed to be impeached, that would be the institution's point of view, and they would cohere, right? Well, we know they don't do that, right? The Republicans do their thing, the Democrats do their thing, and if your president's in the White House, you side with your president. And so impeachment doesn't work anymore in that light. So we're trying to create a mechanism where it would actually be more functional. And so those were actually really, really productive and useful conversations, but also very technical and, getting into some real implementation questions that were, really ultimately pretty fun.
Anything you want to add about the impeachment and term limits, and then focus, if you will, on the amending the amendment. You made it a bit easier, not much. Why did you decide that was the right level, given the fact that the Constitution is now so hard to amend? And moving forward, do you think that your proposal would make the Constitution amendable enough?
Sure. So starting with the confirmation, just real quick, a small observation about that. I do think it was a bigger deal than Caroline is making it out to be in terms of reaching the compromise, in the sense that, from an abstract theoretical perspective, what's 18 years seems enough. Okay, what is the advantage of lifetime tenure? Now, some people will come up with some ideas like, it'll incentivize the justices to do certain things in preparation for their future career or whatever. But, we provided for a mechanism that they could sit for the rest of their lifetime tenure on a lower court, and so they wouldn't give up that job, though, of course, nothing prevents them from retiring or whatever. So you can come up in the abstract with some possible arguments, but it's very hard to argue against 18-year terms, right? The problem is for conservatives. Why do they have any interest in adopting 18-year term limits when they just got the court and they're going to have the court for a long time? So they have no incentive to compromise, okay? Unless there's a legitimate threat of court packing. In other words, if you're going to expand the court, you can get rid of the conservative majority that way. So let's make a deal. We'll give you 18-year term limits and give us a fixed number of justices on the court. Okay. By the way, is this the best way to do a constitutional system? Probably not. I mean, you can come up with a system in which there's a Supreme Court that decides questions of law under statute, and a constitutional court that decides constitutional question. I just was part of a project that brainstormed an idea where the constitutional court would be 7 justices, 7 years. Every 1 year it rotated, and it was chosen by sortition, by lot, among all the sitting judges of the regular courts and so on. I mean, that could be a really great system. But the point is, in the reality that we have now, this was the trade. You get the 18-year term limits, we get 9. And so it was actually quite difficult to arrive at that. And I do think it's important to focus on also the executive confirmations, because as Caroline said, for this to work, when they stagger out, you must get an appointment, right? And so we basically said they're deemed automatically appointed, but the Senate can interfere within the 3 months to approve it sooner or to reject it sooner. So Merrick Garland would have gotten a vote, or been automatically approved under this system. And so that was sort of I think, rather ingenious way that we solved those puzzles. For impeachment, I don't have anything to add on so we increased the threshold, right, from a majority to 3/5 to impeach in the House, and we lowered the threshold in the Senate to convict from 2/3 to 3/5. So now they're both 3/5 vote. So that increases the majority requirement in the House and decreases the 2/3 conviction requirement. I will say that the biggest debate was over the standard for impeachment itself.
It's true.
Right? And I can pick on Team Libertarian, which you'll notice did not get invited today. So they will have to find out how to defend themselves in absentia. But we thought we were clarifying the legal standard by saying that impeachment shall be for serious crimes or serious abuse of the public trust. And I'm not breaking confidences or anything, right? I don't think so. Too late. It's out of the bag.
This in public.
Okay, that's
already.
right.
Yeah.
Team Libertarian, whatever the rule is, Team Libertarian was very fixated about serious abuses of the public trust. They did not want the word serious in there. They wanted any abuse, and they wanted it like a purely political question. They wanted it super easy for the House of Representatives.
We spent a lot of time talking about whether we should say serious abuse of the public trust and serious.
Oh, yes.
Or we should use serious twice or just once. Would it modify both words or whatever? So
this is for the constitutional drafters among you, okay, to the students. This is what we call strategic ambiguity, okay, which I nixed. I vetoed. I'm like, no. This is too important to be strategically ambiguous about. So to get past the compromise, right, where they wanted just abuse, right, they said, well, why don't we say, serious crimes and abuse of the public trust? Does serious modify just crimes or also abuse? And I was like, no, we are not playing this game. Like, this is not the moment for strategic ambiguity. But that was one possible way, to advance the ball. And we just, from our perspective, we thought that clarifying the standard and in that sense making it a bit easier to impeach today by taking out that argument was better. But, we didn't want it to make it too political.
Can I just, a quick little footnote, which is, obvious to all of you constitutional scholars, but, the term high crimes and misdemeanors in the Constitution was variously misdescribed by commentators and over the course of recent years to actually mean crimes, right? And despite the fact that the historical understanding and understanding of the founders, when they crafted this language, was based on its historical antecedents in Great Britain, right? And how it had been interpreted was this much broader sense of abuse of the public trust. And so we wanted to just take that disagreement off the table. We all agreed on that. So, that it was just then sort of crafting this language in a way that would, I think was the libertarians were definitely much more hung up on this wording, whereas I think we would have been able to put this to bed much more quickly.
And then maybe quick thoughts on the amendment provision, and then we'll open it up to your questions. I guess I'd ask, you made it just a bit easier to amend, not much, and I don't imagine all that many more amendments would get through under your standard. So is that about right or not?
Maybe. I guess we don't know. We'd have to try it. But there's lots of things our amendment on amendments did. I mean, there are many ways to simplify the process. I don't think anybody thinks that the current Article 5 process, which requires 2/3 of both houses, right, and 3/4 of the states, qua states, right, I don't think anybody thinks that that is optimal. Right? I mean, so what we decided was, what did we do? We lowered the threshold to 3/5. So from 2/3 and 3/4, we did 3/5 and 2/3. That's sort of the simplest way to at least get it closer to optimal. Maybe it's not enough, right? But certainly it would be easier. I think the Equal Rights Amendment would have probably satisfied that, right?
And it has actually satisfied the current standard, but
outside the 7 years provided by the law. But okay, we don't have to get into that debate. But the other thing that was super interesting, that again, spirit of compromise. Team Conservative did not support this, but we could live with it, which was we also allowed for ratification by states representing 3/4 of the population. So rather than 3/4 of the states as states, where a lot of small states can have these veto gates that stop things from happening, we said states representing 3/4 of the population would be enough. And you do the math, it's about 10 red states and 10 blue states. Like it's not enough to play games with. And quite frankly, in principle, it was just very difficult to find an objection to that process, right? I mean, when you're looking for a process to amend the Constitution.
But it did take us a lot of time to get through.
Yes.
This came out of
Yes,
the
it
Progressive
did.
Constitution, not surprisingly. We had actually a lower threshold to enable popular support. Well, I want to mention, though, something that was really important to us as well, which was to remedy, although not sufficiently, but again, this was in the spirit of compromise, not sufficiently from where we were sitting. But one of the other major anomalies of the Constitution, which is that it purports to take one particular aspect of structure off the table completely, which is the Senate. That is, you basically have to have a unanimous vote of the states in order to change the structure of the Senate. Well, the Senate is a highly undemocratic institution for a democracy. I mean, it has the misalignment in terms of population and representation, et cetera, is a very profound flaw from those, certainly progressives, but many who study democratic structures. And so we wanted to make it, again, somewhat easier to amend the section structuring the Senate. Not a lot easier, not as much as you mentioned, we didn't make it that much easier to amend the Constitution generally, but we made it a bit less difficult to amend the section on the Senate.
Can I say one concluding thought about just the amendments generally and constitutional reform generally, just to keep in mind? The process, so this you should keep in mind when proposing amendments. Would it meet this sort of threshold of support? And then for a process for amending the Constitution, you really wanted to achieve three things, it seems to me. Number one is some sort of bipartisan, broad-based support. Number two is geographic distribution. Right? If the only support comes from the Northeast, or from California, or from Texas, something's wrong with your amendment, right? And then you want it to reflect an enduring national majority. Because if it's not an enduring national majority, then why put it in the Constitution as opposed to treat it according to ordinary legislation if you can? And so you want it, so broad-based support, enduring, so some period of time. You don't want an amendment to be passed overnight, right? You want it to take some amount of time. 7 years, 2 years, 2 to 7 years, some kind of range, maybe a minimum, and you want some sort of geographic distribution. And it seemed to us that the 3/5, 2/3 satisfied that, and it seemed to us that 3/4 of the population, states representing 3/4, also met that, and which is why we were ultimately willing to go on board.
What a great definition of constitutional as opposed to political change. Broad-based support, geographic distribution, and an enduring national majority. That is a crucial distinction between ordinary laws and constitutional principles, and you so well embody it. Friends, it's a privilege to listen to Caroline and Ilan. The level of their engagement, nuance, rigor, and commitment to constitutional thinking is inspiring, and they will now take your question.
I thought you were going to say, but our privilege is expired.
No, there's not at all. Ours continues for our conversation with the audience.
You could ask us more or less anything as long as it's about the Constitution.
Or beyond.
Or reform. Go ahead. I don't know
Thank you very much. I loved what you all had to say. I have a question. The last point you made really struck to your idea of strategic ambiguity. The idea that there are nuances within the Constitution, within the original version, and what has been passed in the years since then. One of the concerns that the framers had as they were going about it was the capability of the regular citizen, as they deemed it, to be able to make these critical decisions. What makes us feel that we are any better prepared now with the current citizenry than we were then? Because once we propose any sort of constitutional amendment, we're going to get lost in our echo chambers. Whether it's a conservative echo chamber or a liberal echo chamber or the progressive echo chamber, we're going to get lost in that, and it's going to be more partisan divided than anything else. So is there really a path at all anymore to make changes legitimately to the Constitution? Just as a quick sidebar to that, you go through the process, or you all went through the process of this Constitutional Convention. However, it seems that the Constitutional Convention could come to agreement with compromise because they knew that it was an exercise. They knew that this was an academic exercise. They knew what it needed in order to achieve the goal. Is that realistic in the world, in the political world that we're living in now, in the constitutional world that we're living in now?
Can I just
He said you wasted your money on us, Jeff.
No.
Never.
So, I actually like to start with your second point, I think, which is, is there a path to this outcome? I think there is. And when I think about a variety of things that have happened in the last number of years, you can see real commonality that happens in terms of states' actions, either state legislation or state citizen initiatives, which reflect a much greater commonality and agreement over a variety of issues than I think we often see. And I don't want to mention them here because I don't want to become divisive again, because some of them are in areas that I am strongly supportive of. But I do think it shows that when people are in their own states, they can often do things that, as citizens, when they break out of their kind of party identification. I think it's, and I think, if we believe in democracy, we have to hope in some sense that there's a possibility of change for the better. I would like to just actually clarify, which is to say we were not engaged in a project where we had to reach agreement. We never were there. Jeff was nice to us regardless of what we did. We were given full leeway. We never, as I said, we never expected to actually be in that room. We wrote our Constitution separately. It was only afterwards that we discovered that there was overlap, and that when we came together to try and craft language that would actually represent a meeting of the minds in those areas, we never had this prospect that we would. We never knew if we were going to get there or not. And there were certainly things that we left behind. There were some areas where we thought maybe we could have agreement on gerrymandering, for example, on the Electoral College, where I think there was some hope that might be somewhere we would be able to reach agreement. But no, I think that I don't think we were all that different really from what would happen with a group of citizen conventioneers who were wrangling over language.
And let me just say that it may be impossible, but it's imperative. And I say this as Team Conservative, and I say this as an originalist. I actually think the Constitution we have as amended, especially by the second founding, and the Reconstruction Amendment, is pretty good. It's pretty good. It doesn't do as much as some people want, but that's not what a Constitution's for. It's not there to do everything that you think is good and just in the world. It's there to create a framework to channel ordinary politics and to balance these competing objectives of self-government and liberty, right, which is very, very difficult to do. But at the same time, if this thing doesn't get amended once in a while, people are going to start disrespecting it for that reason and abandoning it for that reason, or trying to alter it through other mechanisms like conservative living constitutionalism or progressive living constitutionalism. So I really think it's imperative. There is this balance, right? There's this beautiful exchange of letters between Jefferson and Madison that forms the, okay, I'm self-promoting way too much here, forms the basis of the title of my first book called A Debt Against the Living, where Jefferson basically said, look, every generation needs to have a constitutional convention for its own, a constitutional revolution of its own. Every generation is entitled to that. And Madison said, no, if a constitution is an improvement, can be an improvement of this kind that forms a debt against future generations, against living generations. But even Madison recognized, well, wait a minute, we rejected the Constitution of 1776, the Articles of Confederation, and the innovations, they were imperfect. We had to improve upon those. And so it's a balance in that respect too. You don't want it to be every generation. You want it to have stability, but it can't be so stable and untouchable that in 500 years, we will be totally alienated from it. And so it's imperative. It's imperative that we amend this at least once in my lifetime, and maybe do the low-hanging fruit today was the natural born citizen. And I was very dispirited though to discover that apparently like 70% of Americans disapprove of that idea of getting rid of that, which I just learned recently. But it seems low-hanging fruit to me, but I'm sure we could find some other low-hanging fruit maybe that more people agree on.
Very powerful.
Thank you for this discussion. Very interesting. My understanding is that the Constitution of the United States really was never adopted without amendments to start with. That actually the first 10 amendments were a part of the original Constitution, and it was ratified as a whole. Is that not correct, or am I?
So some states ratified on the condition that the Bill of Rights later be proposed, and it was they were proposed after, and it was ratified in 1791. But you're right that Jefferson and the Anti-Federalists' main objection was that there was no Bill of Rights, and the Bill of Rights was quickly proposed.
So in effect, we've had 17 amendments in a little bit more than 200 years, and the point of how difficult it is to amend and how out of sync it becomes with the population, I think probably the best example of that is the Equal Rights Amendment that has been ratified by the states, should be a part of the Constitution, but is not, because I think of some federal rule about how long the process has to, a time frame that it has to be. So where?
Well, it has to do with the enabling legislation and that set a time frame, and the question is that actually operative, right? Does that control? It's not a constitutional element to say that this has to be adopted by the states within a certain period of time. So that is contested. The other thing that is contested is that some states have purported to undo their ratification. So is that constitutionally legitimate or not? And so those are, and the other thing that is really bizarre that we've been wrestling with in another project is who gets to decide whether something has been appropriately ratified by enough states?
William Seward.
Right? We don't really have a mechanism for that. It's been left to the archivist of the United States. Well, guess what? Why? I mean, it's a presidential appointment, and it's a ministerial role, but it has given well. So this controversy has somewhat played out because the Trump Justice Department issued an opinion that the ERA was not effectively ratified, and so directed the archivist. The Biden administration hasn't done anything to reverse that. But it's all so bizarre anyway. It's something that is an anomaly in the U.S. Constitution that would be great to sort of remedy, to figure out, can the Congress set a certain period of time? If so, how long? Is that controlling? Can a ratification be taken back, and who ultimately gets to decide if something has been appropriately ratified in the appropriate time?
And the 27th Amendment, just one day, the National Archivist in 1992 started printing pocket constitutions with a new amendment in it, at the end, because they decided that the 27th Amendment had been ratified.
Is the congressional pay.
Which was first proposed in 1791. 1790.
So in theory, it shouldn't be under the, it took too long kind of theory.
In the back. Two good questions there.
I guess I'm up. Okay. Just I don't know if it's a question or a comment. I've had a chance to read the Constitution the last 3 or 4 years, many times over. And I don't have a PhD. I don't have a law degree. I don't have an English degree. When I read it, it's pretty simple language. It's not that complicated. Yet we have a conservative view and a liberal view, and judges are supposed to be impartial. They're not supposed to be political. How do we get such a wide divide with something that's pretty common language? I mean, Teddy Roosevelt said, if it's not in there, I'm going to do it, right? I mean, how do we get there? What's the history of the divide that one interprets it one way and one interprets it one other way when it says in pretty simple language, this is what it means? Does that make sense? I don't know.
Well, I guess so. We disagree very much on this particular point, which is, it's a wonderful document. It's very short. The language is very hortatory and inspiring. It's hard to apply it to a specific legal question in a lot of circumstances, and a lot of questions that arise in the modern world that were obviously not anticipated. And so when you look at a constitution and try and understand how it applies, you have to sort of say, what does equal protection mean? It's not at all clear what equal protection means if you don't also look at history and how it's been understood over time, the applications and the consequences. Because does equal protection mean everyone is treated the same at all times? Does equal protection mean something more expansive? That equal protection means understanding the disabilities that people bring to, the same starting place. That is, some people were born poor, some people, this or that. Is that part of equal due process, for example? I mean, so there's lots of parts of the Constitution that I think are much more nuanced than that. It makes for something you can fit in your pocket. Try fitting the German Grundgesetz in your pocket. It's, they go through, everything that you could possibly identify. It's in their constitution, their basic law. There are certain parts. The president needs to be 35. That's pretty clear. There are other parts that are pretty straightforward, but there is a lot that I think has enabled us to have, a good several centuries worth of debates over what the Constitution actually means.
So I'm going to disagree with Caroline 75%, and I'm going to disagree with you 50%. If that's okay. I think that the reality is a lot of these provisions in the Constitution are not actually straightforward and simple because they're actually written in legal terminology, legal terms of art. And so by that token, it might not be obvious to the layperson. So that's my disagreement, 50%. But my agreement with you, 50%, is because these are actually legal terms, a lot of it is much more precise than progressives have led us to believe over the last several generations. And Caroline and I, we know we disagree with each other about this. The protection of, so Caroline says equal protection. I would say protection of the laws. What was the protection of the laws? Turns out it's in William Blackstone's Commentaries on the Laws of England. Turns out it's in John Marshall's opinion. Turns out it was in all sorts of legal treatises, and it meant protection against private violence.
Let me just say, though, that originalism is now turned to something called original public meaning. So when you start
inconsistent, maybe
talking about the public, you're already moved away from Blackstone and Cicero and the other elite and great intellects of the law.
Yes, but you can see why the Constitutional Convention was really fun for us over there for 3 days, because I was quoting Blackstone and she said, "You hypocrite," So John Bingham was asked on the floor, of the Senate of the House when they were debating what would become, the 14th Amendment. What is due process of law? That's vague. And John Bingham said, "The gentlemen may consult the court decisions. They've resolved it long ago." Sort of this precise legal meaning and so on. And so for what it's worth, in a lot of my scholarship, and in my book, I try to make this case that these are actually written in what we call the language of the law.
Just jump in again. When obviously he says,
this is not going to end this way.
Decided in cases long ago. Well, that just makes my point. The law has been interpreted and updated and analyzed to apply to current situations that weren't anticipated, and the language doesn't give you the answer.
This is a wonderful modeling of the way debates about constitutional interpretation and methodology are supposed to take place. There's a very serious debate on the Supreme Court right now, and that's why the Constitution Center is so committed to urging you, citizens, to learn these methodologies of constitutional interpretation, just as you introduced them, sir. You were defending textualism and perhaps originalism, and it's important to learn that, as well as Caroline talked about precedent, and there's also structure, and she mentioned pragmatic consequences, and there's also natural law, and we have teaching materials about this, and are trying to inspire middle school kids to learn them, actually, because when you learn these methodologies, you're nodding because you know how important it is. You can separate your political from your constitutional views, and we can have a constitutional debate where people may come to results that differ from their partisan conclusions. And it's vigorous and it takes some time, but you don't have to be a lawyer. And that's why I just love hearing Caroline and Ilan model
But you should
it so
pay
well.
us for your.
Well, we're getting dessert. And you guys, you didn't mention the incredible reward you got for proposing 5 amendments, which was an excellent bottle of wine.
This is true.
Yes, in the back.
Thank you all for the great conversation and discussion. Caroline, you mentioned when you talked briefly about keeping the journalists out of the room, and how I took that as keeping the theater out of the policymaking. I know this was an academic practice, but in reality, this probably shows my politics, but we have a large imbalance in corporate versus the common citizen's interest. With the passing of Citizens United in, I believe, 2009, the imbalance has grown, exponentially. So, in this, during your conversations, did you deliberate on the amount of corporate influences on the practices on the amendments that you were trying to make?
Thank you so much for your question. This was not an area that we could even begin to talk about in the convention. The Progressive Constitution did have a provision that would have enabled Congress to actually control campaign finance spending, as it had tried to do the Federal Election Campaign Act, FECA, that has been basically disassembled by the Supreme Court, and enabled independent expenditures, which is Citizens United in a lower DC Circuit case called Speech Now, that essentially enabled this massive amount of spending by what are called independent entities, which I highly recommend. So I teach this in my legislation class, where they learn about the different structures, that how lawmakers are actually constrained or not by corruption law, by lobbying restrictions, or by campaign finance restrictions. And the Supreme Court has really made it very difficult to enact those kinds of laws. Even Congress tries to do it to itself, to constrain the kind of role of money. There is a really wonderful couple of episodes of the Colbert Report that you can still find on the internet, where he talks to Trevor Potter, who had been appointed to the FEC as a Republican chair, and then was John McCain's campaign counsel, and he sort of talks Colbert through setting up a super PAC, and how he could run for president and still coordinate with the super PAC, which had, could do all these so-called independent expenditures. So lengthy answer to you. It's obviously something I care about a lot, because I think it's a really important problem in our democracy, is how do we have some kind of mechanism to ensure that it's the people's voices that are being heard, as opposed to simply large concentrations of wealth. We don't really have an answer for that at all, apart from, I think, hopefully persuading the Supreme Court at some point to reconsider its opinions in those cases. But our our Constitution did actually enable Congress to enact reasonable campaign finance reforms.
Wonderful, thank you.
Citizens United was correct. No, okay, I just,
Thank you so much.
I don't want to spoil dinner with Caroline later, so let's.
And we have time for one more question.
All right, very, very quickly here. I'm going to prove that I was paying attention at our Constitution Day programming 2 years ago. And we had John Koval and Wilfred Codrington with us on that
We
day.
love Wilfred, okay, yes.
Okay. And they posited that it is during these times of distinct polarization that we create or till the soil for new amendments to take root. And I am curious, agree or disagree?
So I love Wilfred and John. I actually reviewed their book for the Washington Monthly, and I did a program with them for the New York Public Library about the book, so I'm a little biased here. But to say, I think they make a very important point, and why, back to the first question actually, about why I guess it's hopeful and scared at the same time that I think constitutional amendments, they never happen until they happen. We never think they can happen, and then there's some kind of convulsive public engagement. It could be, something really terrible like a civil war. It could be a mobilization that of a kind of reform movement that takes a number of amendments along with it and social change. That is the 16th, 17th, 18th, 19th amendments. So I agree with them very much. I think it's really it's a really good book. I can't remember the exact title, but it's worth reading. You can find Wilfred Codrington and John Cowell with a K.
Ilan, last word?
About this specifically, or can I?
Whatever you like.
Whatever I want.
Send us off with a spring in our step.
Yeah, okay. So let me just spend, since we have 3 minutes left, all the things I didn't get to say. No, Teddy Roosevelt's stewardship theory was wrong. So to the gentleman who invoked Teddy Roosevelt, because his view of the Constitution was that if Congress hasn't prohibited me from doing it, if the Constitution doesn't prohibit me from doing it, then I can do it. That's actually not how the Constitution works. It turns out that the president cannot do something unless authorized by Congress, or unless he or she can point to a specific presidential prerogative in the Constitution. So he's wrong about that. I will say I was flippant about Citizens United, but since I have a minute, let me just say that I feel like the Supreme Court's practices these days is to annoy as many people as possible when it writes its opinions, when it could do things much more simply. And then we could fight about it. Okay, I don't have a solution to this corporate influence and money in politics, but I do know that Citizens United was rightly decided for the following reason. The New York Times is a corporation. Does the New York Times have the right to publish an editorial a day before Election Day saying, Trump is evil, don't vote for him? Of course it does. And of course we would say any law trying to prohibit that and them spending all the money they want to disseminate their publication, we would say is unconstitutional. Well, another corporation calling itself Citizens United can publish a movie about Hillary Clinton a month before Election Day. Same thing. There's no difference in principle between the organization called Citizens United and the organization called the New York Times. It is not a free speech case. It is a free press case. Okay, the Supreme Court could have said that in a page rather than the 100 pages that Anthony and Kennedy took to make that decision. And then we can at least fight about the real problem, which is, hey, there is an issue with corporate influence and money in politics, but the First Amendment is the First Amendment, and if the New York Times gets to spend all the money it wants disseminating its opinion, so can they. And then we can channel our energies to a solution, as opposed to fighting about the First Amendment, which I think is what the Supreme Court created. Sorry, Jeff, that wasn't inspiring or anything of that sort, but at least I got to say what I wanted to.
Well, it was what was inspiring, and I'll send us off, is listening to
smart choice.
Listening to both of you. One of the wonderful gifts of this Constitution drafting project is that we've taken the show on the road and are traveling around the country to model this debate and inspire people to debate constitutional change. And just as at lunch, I urged all of you to continue your deep reading, I want to urge all of you now to continue the deep listening. And the fact that you showed up tonight to spend an hour and a half listening to complicated arguments on both sides allowed you to see what constitutional debate is supposed to be. And this is a model of how to disagree without being disagreeable, to find unexpected convergence and to model the Republic of Reason. And it takes time, and it takes mindfully bringing together people of different perspectives. And look how much light emerges. It gives me hope for the future of the Republic, that if brilliant and diverse thought leaders like Ilan and Caroline and their colleagues can actually come to agreement on fundamental principles, there may be hope for the United States of America. Thank you so much.
Thank you to our panelists so much. That was fabulous. And I think after being here all day, I have a lot of thinking to do and to let myself immerse in it a little bit more. So thank you for that wonderful learning opportunity. Thank you all of you for joining us. I will invite you to head out into the reception area for dessert, for book sales and signing with our guests. And thank you for joining us for the 2024 Progressive Conservative Summit. With that, I wish you safe travels and a wonderful evening.